I've been taking my time, taking all of your time, taking all of your time.
Hey, my trendies, trendsetters, and my trendy tribe. Mic check, 1 2 1 2. Let me know if you can hear me. Let's see, I got YSL stuff up here. Ooh, this day 120, was it day 12220? This is day. Whatever day this is 12 hours, y'all. My notes are crazy. Okay, so let me take this down. All right, I'm going to do quick greetings. I have a couple of, let me see if my friend did what they were supposed to do. Hold on. Because I have an announcement and I'm supposed to have something to go with my announcement. Ooh. I didn't get it. Okay, I don't see it anywhere. Well, okay. I don't know. Okay, well, we'll wait on that announcement then. Okay. Whew. Other announcements and greetings. Let's go. All right. Hey, Auntie Natty coming in at number 10 on the like count. Professor Purple Queen. Hey, Niecy D. My lovely Linda Gamble, one of the hardest working mods on YouTube. Hey, VG, number 23. Hey, Pat Dyer, Purple Unicorn, Daphne Brown. Bama Girl said, I'm back, number 1. Hey, Ebony Dancer, Feminine Leo. Come on, Leo. Hey, American Born, number 26. Joyce Jones, Trish K10, Janetta Speaks, Baby Peaches, Cricket 22, my big sis Peaches and Cream coming in at number 29. Thank you. I appreciate you. Hey, Cheryl Randall, and Peaches and Cream is part of the Mod Squad. Hey, God's Grace, SC is in the building. I'm going to go a little bit more and I'll stop. Auntie Natty, hey. Hey, Pisces Goddess, and Terry T Baby. Hey, Terry. Okay, so let me get my screen up that I actually need because we have a lot in general today. So, announcement time. I am 46 subscribers away from 10K. Now, don't pity subscribe to me. Only if you actually find yourself coming back. Please make sure you hit that subscribe button. I would greatly appreciate it. I am within a stone's throw of 10K, and I definitely appreciate all of you that have been here, the new people coming in, learning my personality. I appreciate all of y'all. For my YSL trial enthusiasts, we will be, if I can get through that 12-hour live stream today with my notes, we're going to go over today. If not, we'll go over Sunday because Shart is cross-examining Woody and still ended at the beginning of the day with some really good ending questions for Woody. So I can't wait to review that with y'all as well. But I can't wait to see Shark, because they said Shark out there cussing. He don't care. He ain't spelling out curse words like still. He's like, I'm cussing. So I can't wait to review that with y'all. I am going to just say this in general. And I can't say too much because I don't know how much I can say. But I was supposed to have a visual with this, but I don't have my visual. But Don Don is about to premiere his second annual awards show. So please be on the lookout for that from his channel. That's all I'm going to say, because I don't remember what I can and can't say. So that's all I'm going to say. And he also has his brunch coming. He has a whole brunch tour with dates. He out here thinking he's doing something big. But September 15th is Dallas, Texas. October 20th is Charlotte, North Carolina. October 27th is Washington, D.C. And Nightbot is dropping the links if you would like to get a ticket to go to one of those locations. I know I RSVP for the D.C. one. That's mine. I know I'm going to be at D.C. Okay. Now, if my screen doesn't mind coming up, we can get to what we came here for. Make sure I only have up what I... Yep. Okay. Now, some of this, I will say... a couple of things when we get into the documents with Destiny and LeBerick, it could be triggering. So trigger warning just for sensitivity purposes. I'm also going to say this. There was a part that Destiny had requested the court to seal. Well, she wanted the whole case sealed. The court denied her, which we're going to look at the motion and the order responding to that. But I do want to say this. One of the parts that she was asking to be redacted was because it was some things on their child. So I just redacted a sentence that I felt applied to what she was trying to get sealed, because for the overall thing of this case, it doesn't have to, that's not crucial enough to just have it showing anyway to see how she came to owing him $19K, and facing a few days in jail. So I redacted that part about their child. And if it comes up again in the rest of the court documents, I will do my best to redact that part, because I get it. The kids, I get it. And that was so specific. And I'm like, I don't like Destiny, but I'm going to still redact it. If my brain is being aware, I'll try to keep redacting that part, because I understood, even if that wasn't her true motive for wanting the records to be sealed, that's still, I get it. I just get it. I get it. So that part is redacted. So we're about to go through a few documents today. Shout out to the Trendies for sponsoring all the court documents. I appreciate y'all. I literally can't keep up with this many cases without y'all. So I thank you very, very much. If you would like to contribute, my Cash App and Venmo are trending at some point if you would like to, and you are never obligated. It's just, I appreciate it if you do. Okay. So we ended on LeBerick filing a motion for emergency relief. And I did correct myself in a Scope versus Zen Gardens video, I think, but I'm going to correct myself in this one as well. I said that for sure the court had granted LeBerick the deed solely to him because Destiny was holding up everything, but he only filed a motion. But the court, in the order we're about to read, did not actually grant him sole ownership of the deed. So that part did not happen. Now, they still have some stern warnings in here for Destiny, but that part did not happen. So I had to correct myself because I made an assumption thinking that when I saw the order, it would have said that. So I apologize, but I had to correct that. I don't want that hanging out there. Okay, so let's get into it. So we have LeBerick Williams versus Destiny Williams, order on verified motion for emergency relief. Hold on, Bama girl. Let me see. Oh, heck, I got to get into my other Cash App. Let me start reading this and let me start logging into my thing. And then I will definitely say thank you for the Cash Apps. I got you, Bama girl. Okay, so it says this matter is before the court on the plaintiff's verified emergency motion for an order directing the entry of a clerk's deed, motion for contempt, and motion for immediate order removing party from real property. This court has had numerous encounters with these parties and the continued alleged acts of contempt. The matter currently before the court was the subject of a hearing on Wednesday, September 27th, 2023. At that time, the court directed the defendant to vacate the property by 12 midnight on the 29th of September so that the sale of the residence as agreed to in the divorce decree could proceed. According to the motion currently before the court, the defendant has failed to vacate the marital property and sign the closing documents as required. The plaintiff's request for a clerk's deed seeks this court's conveyance of the defendant's interest in the property to the plaintiff, despite there being no provision in the divorce decree providing for the same. The plaintiff, although frustrated by the continued delays of the defendant, does not have the right to all interest in the property. However, the plaintiff is entitled to specific performance of the terms of the divorce decree, including the sale of the marital residence. That was to take place on this date, September 29th, 2023. Therefore, it is ordered, adjudged, and decreed that the defendant shall immediately sign all documents for the sale of the marital residence to proceed, and in any event, no later than 6 p.m. on this date. So the same day that this order was done, Destiny court didn't want to hear it. She had to sign what she needed to sign and vacate what she needed to vacate. Failure to do so will result in a determination of contempt at the hearing set forth below, including a determination as to whether the defendant should be held in the Madison County pending her compliance with this court's order. Furthermore, should the defendant fail to sign such documents, the sheriff of Madison County, Alabama, is hereby directed upon notification by the plaintiff to immediately remove the defendant from the marital property. Having considered the same, it is ordered, adjudged, and decreed that the defendant, Destiny Williams, shall appear before court at a hearing to be held on the 4th day of October, 2023 at 9 a.m. to show cause, if any, why she should not be held in contempt of court for willfully refusing to comply with the previous order of this court and the provisions of the decree of divorce. The defendant's counsel shall provide a copy of this order to her, and a copy of this order setting hearing shall be served upon the defendant. The defendant this is one of those another stern instruction. The defendant is hereby placed on notice that in the event the court should make a finding of commission of willful and intentional acts by the defendant resulting in a determination of criminal contempt, the defendant may be incarcerated as a result, or if found in civil contempt, the defendant may be incarcerated until such time as she has complied with this court's order, done this 29th day of September, 2023. Okay, so that was September 29th, 2023. We saw the order. Now, what was this one? This is what the court also received as a filing on September 29th, 2023, the same day as the order that the court just issued about, having to prove why she shouldn't be held in contempt. All of it, right? Okay, so September 29th, 2023, suggestion of bankruptcy. Comes now the defendant, Destiny L. Williams, and gives notice to this honorable court that she has filed for relief under Chapter 13 of the United States Bankruptcy Code in the United States Bankruptcy Court for the Northern District of Alabama. The defendant filed her bankruptcy case on September 29th, 2023, and relief was ordered that same date. So the same date as that order was just published that we just read, her attorney says she filed for bankruptcy. Now, how does that affect this? This is what happened because of that. So, because there's a suggestion of bankruptcy, the court said this is the order on suggestion of bankruptcy. The court being advised that the defendant filed a petition in bankruptcy court, it is ordered, adjudged, and decreed by the court that this matter is stayed until the plaintiff obtains relief from the bankruptcy court and files with this court leave to further proceed against said defendant. And just for some of us that like to look at the terms, hold on, I have it here. Okay, a stay of proceedings is a ruling by the court to stop or suspend a proceeding or trial temporarily or indefinitely. A court may later lift the stay and continue the proceeding. Some stays are automatic, but others are up to judicial discretion. Usually the pendency of an appeal stays proceedings in the court below. Okay. So right now, this case was suspended because of her bankruptcy filing. Okay, so that was the order that the court issued on October 3rd, 2023. And I think, let me make sure. 1 second. I just want to make sure. Okay. And they were going to have court October 4th, 2023 about why she should not be held in contempt. So then months later, how far? That was 2023. Now we have skipped to 2024, March 5th, 2024, because y'all saw through our content creators that LeBerick had to file in bankruptcy court that he did not want to be held to like releasing her of whatever she owed him her obligations based on the fact that she filed for bankruptcy. The bankruptcy court granted his request, and so that then he took that back to this court to file a motion to lift the stay or suspension. And it says the plaintiff, by and through the undersigned counsel, states as follows: this is an ongoing contempt action. The present litigation has been stayed since October 3rd, 2023, due to the defendant's filing a petition in bankruptcy court. The judge in the bankruptcy action has entered an order permitting the lifting of stay in this domestic relations action. The real property previously at issue in this action has been sold. Several requests for relief made by the plaintiff herein are now moot due to this sale. However, the numerous additional claims of contempt and requests for relief remain active. The plaintiff requests this court enter an order lifting the stay on these proceedings so that all claims herein may be adjudicated without further delay. Wherefore, the plaintiff moves the court to enter an order lifting the stay on litigation in this matter and any and all further relief to which he may be entitled under the circumstances. Okay, so that was, now we went from September, October 2023, and this was filed March 5th, 2024. And then the court's order on LeBerick's motion, March 6, 2024, it says order on motion to lift stay. Motion to lift stay filed by LeBerick Williams is hereby granted. This matter will be set on the court's next available docket, done this 6th day of March 2024. Some of you had posed the question, and I didn't go back and look, and I'm already bad with names, but some of you had asked, what's the judge's name in their case? Because y'all wanted to know if it was the same judge in Melody and Martell's case with custody and all those things. This judge is Ruth Ann Hall. So if that's the name y'all saw on Melody and Martell's things, then there you go. But this is this judge's name, Ruth Ann Hall. I am going to say, just for sake of, I have to say it because I can't not notice it. If this is the same judge that is presiding over Martell and Melody's case as well, when I'm talking about the child custody and things like that, it seems like she's already going to lean on the man's side. Now, I'm not saying LeBerick is right or wrong, but I am saying that it's clear Martell was wrong, and she was still like prolonging and is still prolonging so much and giving Martell so much leeway that LeBerick probably got it easy if that is the same judge. I will say that. Now, I'm not saying that they have the same circumstances. I'm just saying that there was a strong argument that the judge that's presiding over Melody and Martell's case really is leaning towards, even if it's not reasonable, leaning towards the dad. That's just what I've heard people say a lot. So, I said she got on my nerves a couple times too. I have said that. So if that's the same person. Okay, so then now we're on to March 8th, 2024. Another order was issued. In this order, it says, it is ordered, adjudged, and decreed that the above referenced matter be and the same is hereby set for trial on Tuesday, June 4th, 2024 at 9 a.m. Okay, now this bold part right here, let me go ahead and zoom in for y'all on this one. Let me zoom in, because this is where Destiny, she tries. She always tries, but the court is informing Destiny. Hey, Don Don. The court is informing Destiny, and anybody, I'm sure that's like a standard statement, but Destiny always be trying to continue stuff. But it says it is the responsibility of the party and or lawyer to determine if a personal conflict exists upon receipt of this order and inform the court. Failure to determine if such conflict exists will result in a denial of any motions to continue for prepaid trips or other personal issues. Counsel shall comply with the 23rd Judicial Circuit's procedure for conflicts by providing the appropriate notification of conflicts to the court administrator. Counsel are urged to familiarize themselves with the procedures so that conflicts can be resolved between judges prior to the scheduled trial date. Okay. I'm sorry, that might have been for the lawyer. There's one coming up for Destiny. My bad. That might have been just for counsel. Okay. Now we have notice of appearance. When I was telling y'all Destiny is not going to have the same lawyer she started out with. So we're on May 3rd, 2024. And it says notice of appearance. It says comes now Kristen D. Butler and enters her name as the attorney of record for the defendant Destiny L. Williams in the above styled cause this the 3rd day of May 2024. So this is a new person entering themselves as Destiny's attorney. So she had another counsel before this next thing comes out, which is the motion to withdraw. Okay. So motion to withdraw. Comes now Rebecca M. Winters, counsel for Destiny Williams, and files this her motion to withdraw as counsel in the above referenced case, and as reason thereof will state as follows: the defendant Destiny Williams has hired new counsel and wishes to proceed with her new counsel. All right. So now we're on to May 7th, 2024. The court says motion to withdraw filed by attorney Rebecca Winters as attorney for Destiny Williams is hereby granted. The withdrawal of counsel does not relieve the pro se party from compliance with this court's deadlines and requirements under Alabama law. This is the one that was the warning for Destiny for sure. It says, additionally, hearings and trials will not be continued if the party does not have or has only recently retained counsel. So that cannot be a reason to delay the court proceedings as they were scheduled just because you changed counsel. That was the warning I was thinking of. This matter is set for a hearing on June 4th, 2024, which was the date they gave earlier. So it's still the same trial date, June 4th, 2024, and will not be continued. Counsel shall provide the defendant with a copy of this order and certify to the court that this has been completed, done this 7th day of May, 2024. Okay, hold on, because I'm going to get timed down on doing my confirmation code. Hold on one second. Where's this at? Sometimes it's just too many notifications, y'all. Where'd it go? Y'all. I know y'all like, we can't help you. We can't see what you're looking at. But I don't know. Oh, God. Well, it's going to time me out and try again later, I guess. Okay. So now we have a motion to order production of records and for a protective order. This was filed by Destiny and her attorney. It says, comes now the defendant, Destiny L. Payton, by and through her attorney of record, Kristen D. Butler, and requests this honorable court to enter an order requiring any individuals and or entities issue subpoenas for records and or appearance to respond to and produce those records requested by the subpoenas, and to enter a protective order regarding the same as grounds therefore states as follows: that said information is protected under the federal HIPAA Act, and said records qualify as protected health information under said HIPAA standards. That said information requested is crucial to the presentation of defendant's case to this honorable court, and that significant issues exist in this case necessitating said documents, including medical expenses, custody of, and or other issues related to the party's minor child. Pursuant to HIPAA, a protective order is necessary to allow for the production of these documents. So that was May 7th, 2024. Now we go to the order from the court regarding the request for HIPAA records. It says HIPAA order authorizing disclosure of mental health records. It says, upon compliance with Alabama law, the attorneys for the parties and or pro se parties to this lawsuit are permitted to obtain all health information, including charges therefore relating to plaintiff LeBerick Williams and defendant Destiny Williams. This order neither broadens nor restricts any party's ability to conduct discovery pursuant to Alabama law. This court order authorizes any third party who is provided with a subpoena requesting the production of documents or commanding attendance at deposition or trial to disclose protected HIPAA in response to such request or subpoena. The court finds that this matter involves a child custody dispute and that any applicable privilege is due to be waived. Accordingly, this order permits disclosure of confidential communications made for the purposes of diagnosis or treatment of a patient's mental or emotional condition, including alcohol or drug addiction among the patient's psychotherapist, and persons who are participating in the diagnosis or treatment under the direction of the psychotherapist, including members of the patient's family. This order further permits disclosure or information relating to HIV testing or sexually transmitted diseases. Nothing in this order shall be construed to authorize any party or any attorney for any party to release, exchange, submit, or share any protected health information with any other person or any other entity other than an agent or employee of the attorney or party. This order prohibits parties from using or disclosing the protected health information for any purpose other than this litigation or proceeding. Because Congress, in promulgating HIPAA, intended to enhance patient privacy, and because nowhere in the Act or its regulations is there any suggestion of a congressional finding that a patient waives their privacy protection when they file a lawsuit, this court, in the exercise of its discretion, orders that ex parte communications between any party and his or her attorney, agents, insurers, or other reps and the opposing party's treating physicians are hereby expressly prohibited. Subject to the provisions of the Alabama Rules of Civil Procedure 26, the party's attorney may request interviews with any of the opposing party's health care providers, health plan administrators, or other individuals concerning such opposing parties' protected health information, done this 7th day of May 2024. So all that to say, they're ordering disclosure of records only to the extent of the already existing law, nothing more, nothing less. And it cannot be talked in with outside parties, all of that just for the purpose of what they need it for this case. And then they have to, of course, destroy everything after, or what does it say? At the completion. Let's see. That's not what they said. Okay. They have to return to the requesting party the documents and all copies thereof containing protected health information. Let me read that right. Okay. Let me see here. This is where I was telling y'all Destiny filed a motion to seal this case that we're reading right now. Obviously, if I'm still reading it, it was not sealed. But I'm going to read it out to y'all. And if you came in later, what I was saying was the part that even though the court denied it to be sealed, I tried to redact the part that she wanted to be sealed because it was about the minor and it wasn't pertinent to why she owed $19,000. So I still just redacted it. I am trying to fight with my phone at the same time and I don't appreciate it. Hold on, y'all. Here we go. Ooh, multitasking is not the strong suit on a live. Okay, let me really quick before we get into it, let me say thank you. I have, because I don't know where I stopped at, so I'm gonna go back a little bit more. So I'm gonna say thank you to Galen. Thank you, Babette. It keeps scrolling back to the top. Thank you, Sandy. Thank you, Regina. I'm trying to make sure I use the names that if y'all told me a different name, I'm trying to use that name. Thank you, Mims Girl. Thank you, Kia. Bam Bam, I see you, Bam Bam. Thank you very much. And thank you to, I'm going to say GR. Thank you to GR. I'm going to pop the trunk before we read this motion to seal. And again, I took out the part that she was trying to seal anyway. So it just, I just didn't feel right. So I just still redacted, even though the court said they denied it being sealed. But let me pop the trunk real fast. We going.
All right, we going. What a money reside. What a money reside. What a money reside. What a money reside.
Hey, Professor Purple Queen, I just saw you come through. Thank you very, very much. I see you. Okay, so defendant's motion to seal case. Comes now the defendant, Destiny L. Payton, by and through her attorney of record, Kristen D. Butler, and hereby moves this honorable court to place this case in the court file under seal and as grounds, therefore states as follows. That information, sorry, somebody want to come by being loud. that information regarding the minor child's health and related medical needs has been produced in relation to this matter. It is required to reference such in future pleadings and hearings in order for the defendant to properly plead her case and protect the best interests of the minor child. Further, that this is a matter involving issues which are of a sensitive nature relating to the party's minor child. In the past, court pleadings and other documents related to the parties have been publicized and released by third parties, and it would be detrimental to the minor child for any information related to his health, safety, and well-being to be readily available for anyone to publicize. That in order to protect the physical, mental, and emotional well-being of the minor child and the best interests of the minor child involved herein, the defendant respectfully requests that this matter be immediately placed under seal. Wherefore, premises considered, the defendant hereby requests that this case and the court file be placed under seal, including but not limited to any and all court records, including all pleadings, any items entered as an exhibit, any items subpoenaed but not entered as evidence, any trial testimony and or documents related to said trial, and for such other further and more general relief to which in equity and good conscience this court deems necessary and appropriate. Okay. So the court, let's see, she filed that motion on May 7th. The court issued their order on May 7th. And the court just simply put defendant's motion to seal case by Destiny Williams is hereby denied, done this 7th day of May 2024. So, okay. Okay, so now we're on to motion to reconsider the HIPAA order. This is LeBaric that is fighting the HIPAA order of disclosure. So it says, comes now the plaintiff by and through the undersigned counsel to respectfully request this court reconsider its order granting the defendant's motion for HIPAA order, stating as grounds, therefore, as follows. This is the second contempt rule nisi action brought by the plaintiff, LeBaric Williams, following a series of repeated and unrelenting acts of the former wife, Destiny Payton Williams, in flagrant violation of this court's prior orders. No request for modification of custody or visitation in this matter has been submitted to this court. The instant matter concerns the defendant's contempt only. On today's date, new counsel for the defendant has filed a motion for entry of HIPAA order requesting this court allow access to records pertaining to the minor child. As grounds, therefore, the defendant stated, information requested is crucial to the presentation of defendant's case to this honorable court, and that significant issues exist in this case necessitating said documents, including medical expenses, custody of, and or other issues related to the party's minor child. This court thereafter entered an order granting the defendant's motion and entered a HIPAA order permitting discovery of health records as relates to the parties themselves without mention of the minor child. The plaintiff acknowledges that Alabama law permits discovery of health and mental health records of parties in the context of custody litigation. The instant litigation touches no issue of custody. The only items of contempt claimed by the plaintiff which might be construed to require a HIPAA order are as follows. Defendant's failure to reimburse plaintiff for uninsured medical costs. Defendant's failure to notify the plaintiff of medical appointments of the minor child. Access to medical records of the parties and the minor child are not necessary to the litigation of these claims of contempt. So LeBaric is he's arguing that not only is there no reason or relevancy for Destiny to receive I can't get it out. Private health information about him. He's saying it also for her to have it for the child. Now, I would think the mom would need anything for the child. I will say that. But for his, depending on what case she's trying to present, because she has asked about his stuff before when they were going through their original divorce, getting to the point of a settlement, she had asked for his VA health records at that time as well. It says the plaintiff respectfully requests this court reconsider its order granting the defendant's motion for HIPAA order and that this court set aside the HIPAA order granted in this action. If this court sees fit to allow the defendant some access to said records, the plaintiff requests that the same be subject to redaction prior to delivery to counsel or parties to appropriately comport with only the issues at hand. The plaintiff further notes to this court that the defendant has previously used her television series and associated media outlets to besmirch his name and otherwise publish information about this case, and the plaintiff personally, whether true or not. The plaintiff has serious concerns about the disclosure of his medical records to the defendant, particularly given that the same is not relevant to this matter. Wherefore, the plaintiff respectfully requests this court reconsider its order granting the defendant's request for HIPAA order, request this court set aside the HIPAA order entered in this case, and request any and all further relief to which the plaintiff is entitled under the foregoing premises. Okay. I'm trying to do stuff in between. Okay. So now the court did, of course, make a ruling, or they published an order in response to that motion. And let me say thank you, Dr. Minnie, for the $5 super chat towards Legal Document Fund. I definitely appreciate it. Let me go ahead and pop that trunk.
All right, we going. What a money resign. What a money resign. What a money resign. What a money resign.
Okay. And one more thing to go with my announcement that I can show y'all. Don, you know you was late. You know you was late. But hold on one second. Let me see here. Nope, not there. Here we go. My friend, let me see. All right, so I get to exclusively announce, which I verbally kind of said it, but I didn't want to say too much. But starting tomorrow, September 1st, the Starries, the Starlight Awards, reality TV Starlight Awards, put together by Don and his production team, is going live, and you can visit www.thestarriesawards.com to vote. And Don's gonna be dropping the link, I'm sure, tomorrow. I didn't want to drop it early because it goes live tomorrow, so I didn't know for sure. Let me see what my banner's covering up. And you can vote once per day per device, just so you know. And I want to say something else, but I'm just gonna say this: you already know who's gonna be in that category somewhere, so just be looking out and vote for your person. Vote for your person. Okay. Let's see. Black Women Lifestyle said Destiny only needs a medical insurance card and a dental insurance card for their child. Well, for coverage, for insurance coverage, yes. I think that there's been some things that don't cover insurance, and it's supposed to go 50-50 on that. But I do think he's supposed to receive proper notice about that, and they might have to make joint decisions on things that carry over into outside of insurance coverage. And also, I would think as a parent, you are supposed to know anything health-wise about your child. So the order that you're gonna see, this is gonna talk about that they did not even mention the minor child, basically. But yeah, I think because they're talking about outside costs. I think if she's talking about stuff within costs, it did clearly state LeBeric has to cover, everything that his premium would cover with insurance related to the child. Thank y'all for being in here. Please like the video if you have not done so already. If you have come back more than once, please subscribe to the channel. I am so close to 10K. I appreciate y'all. Don, because I told you, and you still did me wrong. Okay, so here's the order. LeBeric Williams versus Destiny Williams. The order says motion to reconsider HIPAA order filed by LeBeric is hereby other. So it's not denied. It's not granted. It's just an other. And the other is, this is where the court, I guess, is clarifying what their order had said about HIPAA. And it says the court's wording of the order was specific and intentional. By naming the parties, it was the court's intention, and the effect of such order is that the child's records will not be obtainable under the order. Done this 8th day of May 2024. And just to say what they said specifically, they did not name the child. It didn't. What it named, it says, is the parties, Destiny and LeBeric's HIPAA records could be requested, pursuant to the law. That's what it said. That's what it said. So, the court still said, yes, she can have access. So it is what it is, as long as used within the legal bounds. Now, here's where the title came from, or the thumbnail came from. We're going to look at Destiny's counter-petition to hold LeBeric in contempt of court, or in contempt, I should say. So that's what this is our last document. This is what we're ending on. Come back at Well, it's actually gonna be earlier because this is not gonna be too long to read. So honestly, y'all, I'll probably see y'all in like 30 minutes from now, if that. The link is already live, but I think I set it out for a little later, but I'm gonna go ahead and knock it out. It's the Scope versus Zen Gardens, and I'll say more details over there because I'm trying to keep these clean with the topics that they're on. But just come back, set your notification on, because when I finish this, I'll probably just hit the live button to go back to the Scope Zen Gardens thing. So just come on right back if you would like to. So this is the last thing. It says answer and counter petition for Rule Nisi. And I had to look some of this stuff up. Rule Nisi, it says in Alabama, contempt/Rule Nisi petitions involve filing a claim against a former spouse and or parent for failure to comply with a court order. Below, or that's it. It said below is a list of issues commonly involved in contempt Rule Nisi. So that's what it is, though. It's a claim against a former spouse and or parent for failure to comply with a court order. Okay. So it says, let me take this down and make sure my redaction is still there. Hold on. I just want to be sure. Hold on 1 second. Let me just double check myself. Okay, yeah, it's still there. Still there. Okay. Thank you, Mims girl. I appreciate it. Okay, it says, answer and counter petition for Rule Nisi. Comes now the defendant in the above entitled cause and for answer to the petition for contempt heretofore filed on June 20th, 2023 states as follows. Defendant admits the allegations in paragraphs 1 and 2 of the plaintiff's petition for contempt as to the date of divorce and the fact that the parties entered into a settlement agreement as of April 9th, 2021. Defendant denies each and every other allegation contained in said complaint. And then these are Destiny's affirmative defenses. It says, having answered the plaintiff's petition for contempt, the defendant sets forth the following as affirmative defenses. The first defense, failure to state a claim upon which relief may be granted. The second defense, accord and satisfaction. And I'm going to tell y'all what that means. It says accord and satisfaction refers to the agreement, accord, between two contracting parties to accept alternate performance to discharge a pre-existing duty between them and the subsequent performance or satisfaction of that agreement. The new performance is called the accord. The next affirmative defense is plaintiff's unclean hands resulting from plaintiff's own conduct or by the conduct of his agents, representatives, and consultants. So if you were here earlier with me a few months ago, I was like, I didn't know unclean hands was an actual legal term. And I was like, what? They're just saying words. So anyway, unclean hands doctrine. It is an equitable defense that bars relief to a party who has engaged in inequitable behavior, including fraud, deceit, unconscionability, or bad faith related to the subject matter of that party's claim. The unclean hands doctrine is also known as the clean hands doctrine and the dirty hands doctrine. The unclean hands doctrine typically applies only to equitable claims, such as requests for injunctive relief or specific performance, but some jurisdictions permit it as a defense to legal claims as well. General immoral or corrupt conduct is not enough to warrant application of the unclean hands doctrine. To prevail, a party must demonstrate that its opponent engaged in inequitable behavior that is related to the subject matter of the litigation. So, let's say for the unclean hands, it would have her attorney would have to prove something specific that happened as far as the divorce settlement, not just he did something in general. It have to relate to the actual divorce settlement. The next one is the next affirmative defense is plaintiff's own failure to mitigate. So she's saying that he did not try to lessen losses that could have been prevented, and he just let them build up whatever the loss is, whether it's money, time, whatever it is. The next one, affirmative defense, Destiny cited and her attorney cited, is fraud on the part of the plaintiff. I'm curious what the fraud would be. I would like to know that. The next one is in pari delicto. And hold on, we're going there. It might be in Paris or in pari delicto. Okay. It says a Latin phrase commonly used in tort and contract law, which means in equal fault. So she's saying that they are in equal fault. This doctrine states that there is a bar to a plaintiff's recovery of damages for a wrong the plaintiff participated in and serves as an equitable defense. Courts are therefore reluctant to award relief to plaintiffs who have unclean hands, and peri delicto is similar to but distinct from the related concepts of contributory negligence and comparative negligence. Okay. The next affirmative defense is unconscionability. And unconscionability is a defense against the enforcement of a contract or portion of a contract if a contract is unfair or oppressive to one party in a way that suggests abuses during its formation. A court may find it unconscionable and refuse to enforce it. So she, is claiming at some point, probably she felt pressured to sign the contract, or it's just unfairly oppressive, all those things. So it just depends on what detail they were going to go into when she claimed that. Okay, the next affirmative defense is justification and prior breach by the plaintiff. So she's saying that LeBeric breached the contract previously. Prior material breach. It says the general rule of contract law sounds simple enough. When a contracting party commits a first breach, the other party is relieved of its obligations under the contract. So if she could have proven that he breached the contract first, she would be free of being held in contempt of breaching the contract after the prior breach. Okay. Then the next affirmative defense is ultra vires. Let me go. Where's it at? Ultra vires. Ultra vires. Ultra vires. I'm trying to look at how, how they tell you how to pronounce a word. I'm over here trying to sound it out. But it says it is acting or done beyond one's legal power or authority. So she's claiming, it says, in that plaintiff has exceeded the scope of the authority granted to him by the prior orders of this court. And her last affirmative defense is the defendant specifically reserves the right to file additional defenses and counterclaims not otherwise stated herein, and to amend and supplement this response. And then I see the chat saying they're praying for Linda. Linda, I don't know what happened, but you already know. I will add you to my prayers. Y'all pray for Bonnie Mason too, with her mom. Last night she found out her mom took a tumble. They were going to go see her anyway for her birthday, but please pray for Bonnie as well. And keep Linda in your prayers. I didn't see what happened, but please keep her in your prayers as well. Pumpkin, I can give you a guess, but she doesn't have to name in these court documents. She didn't name why she was asking for LeBeric's medical records, but I think she's going to literally his mental state in some cases of where she's claiming he acted in a certain way, that she can prove that there is some, maybe she should have primary custody because of his mental condition. Or I'm not saying, because obviously we're not going to see his medical records, but I'm just saying that I'm thinking that's one of the motivations that she might have to ask for his medical records. I don't know what his medical records contain, but if she's asking for the VA and mental health history and stuff like that, I think it's to show something about she was trying to prove it was unsafe for him to be alone with the child, or I'm totally guessing. I'm just guessing, but because of the other protective orders that she had applied for before and some other things that happened during their divorce settlement, that's why I'm guessing that. I don't know. It's just me guessing. Okay. So now we're on to counter-petition for Rule Nisi. So now this is her counter-petition for LeBeric to be held in, I think, civil and criminal contempt of court. So she was also asking for him to be held in contempt, both sides. Okay, it says, now having fully answered the plaintiff's petition for contempt and due to the actions taken by the defendant in contradiction of the orders of this honorable court, the defendant sets forth her counter-petition for Rule Nisi as follows: that the plaintiff has unilaterally changed the medical providers of the minor child of the parties, contrary to the medical decision-making authority awarded to the defendant pursuant to 3BH of the final judgment of divorce as entered by this honorable court on April 12, 2021. Furthermore, the plaintiff has continually, willfully, and intentionally failed to pay uninsured health care costs of the minor. So again, I believe what their settlement said is he would have to pay 50% within so many days, and she'd have to pay the other 50%. So I'm guessing she's saying he didn't pay the other 50%. Now in his 2 claims, he said that she did not notify him of those outside appointments. I don't know if that matters, because if it goes back to the part where it says she was awarded decision-making authority, she may not have to consult with him. I don't know. I'm not a family. Well, I'm not an attorney, period, but I'm not a family attorney. It says that the plaintiff has failed to co-parent with the defendant, refusing to communicate prior to making decisions regarding the minor child, and or communicating his decisions through third parties in contradiction of the standard parenting clauses incorporated in the final judgment of divorce of the parties. So she's saying LeBerick is the one failing to co-parent. He's not communicating prior to making decisions regarding their child, and he's communicating his decisions through third parties, according to her. Part 1 is where we read LeBerick's petition, I believe, against Destiny. If you want to see that in detail, it was part 1, and part 2 shows like not only his petition, but then there's also the settlement agreement that this document is referring back to. If you want to actually see that listed out in detail again to refresh your memory. There's Purple Queen. There's one you're definitely gonna say she does sound like Martell. It's that phrase, first right of refusal. That's where I was like, ooh, that sounds like Martell. Well, depending, not okay. I can't tell you specifically what insurance the child should be under, but it has already been proven that the child is under his insurance. So that's not a problem. He's under insurance, but even insurance will not always cover everything. So there's sometimes outside medical costs that they have to cover 50-50. But yes, he's responsible. Their settlement has him responsible for carrying insurance for their child. So he does have insurance for their child. Whatever insurance is under, he has insurance for their child. Because depending on the type of veteran you are, and then I don't know what VA, and I'm not familiar enough with VA benefits to even speak on it. That's why I'm just like, I don't want to say, but it's under something, because he's got between, I don't know if he still works for Boeing or not, but he has whatever primary insurance coverage he has. Because I'm gonna tell you now, all veterans don't still have TRICARE. All veterans aren't, don't have the VA health insurance. That's why I'm just like, I don't know. Unless he'll actually list it in black and white, I don't know what insurance he has. But they did put that he is covering their child under his health insurance. Yeah, everybody doesn't still have TRICARE when they're a veteran. When you're in, they do, but it's not 100% that every veteran has TRICARE after they're out of the service. Some do under the right circumstances, but not all do. So that's why I didn't even want to say it's not a for sure. I'm not saying he doesn't, but that's not for sure. So to just say that, I don't want to say that. She's responsible for only 50% of the extra, Paulette, not the 100%, the 50%, per their settlement agreement. Okay. So now we're going on to the plaintiff has intentionally and willfully attempted to alienate the minor child of the parties from the defendant. That the plaintiff has intentionally and willfully neglected the medical needs of the minor child by interfering with attempts to have the minor child of the parties thoroughly evaluated and or treated as recommended by the medical providers of the minor child of the parties. That the plaintiff has disparaged, attempted to intimidate, and harass the defendant in front of the minor child of the parties. One such incident resulting in him being ordered to leave the location of custody exchange by a uniformed police officer at the Huntsville Police Department. So Destiny is saying that it got so bad at a time that a police officer told LeBerick to leave during custody exchange. That's what, I'll just reread the sentence so y'all can just get it verbatim. That the plaintiff has disparaged, attempted to intimidate, and harass the defendant in front of the minor child of the parties. One such incident resulting in him being ordered to leave the location of custody exchange by a uniformed police officer at the Huntsville Police Department. Okay. That the plaintiff has violated paragraph 1E of the standard parenting clauses as incorporated in the final judgment of divorce by traveling out of town for overnight travel and failing to inform the defendant of same or provide her with her right of first refusal as set forth in said paragraph. Okay, so that's the part where I saw the right of first refusal, and that phrase, it just, that phrase for me is all Martell. And that's obviously it's a common phrase, but it's all Martell when I hear first right of refusal. So I don't know if that's a part of their settlement agreement he has to choose her or give her the chance. Well, it says paragraph 1E of the standard parenting clause. So maybe, I don't know, maybe he does, because they are citing a paragraph within the standard parenting clause that she did not get first right of refusal for overnight travel. Okay, then it says that the plaintiff has failed to provide the minor child an environment in which he can grow and thrive by intentionally interfering in and refusing to take the minor child to scheduled extracurricular activities and keeping the minor child from school, despite the minor child's documented, and that's the part I redacted, okay, out of respect. But the part about him keeping the child away from school, that's a crazy assertion. That's wild. Okay, it says that further, plaintiff has repeatedly refused to pay his share of costs of extracurricular activities participated in by the minor child and out-of-pocket medical expenses. To the best information and belief of the defendant, the plaintiff has had overnight romantic partners as visitors in the presence of the minor child during the minor child's overnight custodial time with the plaintiff, and the plaintiff is LeBerick, which is an intentional, willful violation of paragraph 2K of the standard parenting clauses incorporated in the parties' final judgment of divorce, that as a result of the actions of the plaintiff up to and including an attempt to have the defendant arrested without justification and plaintiff's failure to communicate or co-parent the child, the defendant has incurred unnecessary attorney fees that warrant an award to defendant of attorney's fees to be paid by the plaintiff. So she's asking for her attorney's fees again. Then it says, wherefore, premises considered, defendant prays that your honor will take jurisdiction of this counter-petition for Rule Nisi, and that upon a final hearing of this cause, your honor will enter a final judgment granting the following relief to the defendant, Destiny. So, sorry, y'all. Yeah, now that yes, Flower Bloom, it is messy. That I agree. Okay, it says, Don said Martell definitely told her this. It says, the defendant further prays that upon a final hearing of this petition, your honor will find the plaintiff in civil and criminal contempt of court for his failure to comply with the orders of this court. So she's asking for LeBerick to be found now also in civil and criminal contempt of court. And further, enter a judgment in the defendant's favor for all sums due to her as past due medical, childcare, and extracurricular activities plus accrued interest. So here's my thing. And I mean, spoiler alert, we're here because we already know about the 19K judgment, right? So I guess the judge would have had to ask her, can you provide proof of expenses you paid that you believe he owes? And I'm guessing if it, now I don't know if like they were like, okay, he did owe the 400 here, the 1,000 here, but then the net was still that she owed LeBerick 19,000. I don't know, y'all, and I don't know what the court documents are gonna show. I can go get the next set, so I will do that. But I'm wondering, like, did she not be able to prove any of this, or did she prove it, but she still owed LeBerick more, so it still ended up in his favor with 19,000? That's one of the things that's in my brain now. It says that the defendant further prays that your honor will order the plaintiff to pay to her a reasonable sum with which to pay her attorney of record for her services rendered to her in this cause, and the defendant prays for such other further different or more general relief to which it may appear that she is entitled. Woo, okay, Disney. Okay. Let's see here. And hey, Melon Beauty. Hey, everybody that came in. Okay, y'all, give me 5 minutes or so, and I'll be live for the Scout Zen Gardens thing. So just, pop on over to the other side in just a few minutes. And I'm telling y'all now in the comments, sometimes I don't even touch the comments sometimes, but I can only literally almost parrot back what the court documents say. So I don't really, I guess sometimes, but I don't really do too much of like saying for sure this or for sure that, unless that's what the document said in the first place. So yeah. So right, Flower Bloom, provide proof. So I'm wondering about that math, how that math ended up. Right, Kay. Or maybe she wasn't awarded any money. I just like, because see, that's the thing. That was my easy conclusion, that she was not awarded any money. So I like to play around with what could have happened in my mind. And I'm like, I wonder if she was able to prove a little bit and it lessened the overall debt she was going to end up owing LeBerry. I was just wondering though. I don't know. We're going to get to it though. So part 5 will be coming. And I thank y'all because again, y'all sponsored these court documents. I appreciate it because that is definitely a quick financial burden. So I appreciate y'all. Let me make sure I have said thank you to everyone, and then I'll see y'all in 3-4 minutes over on the other side for the Scots and Gardens. Let me see here. Okay, I think I covered everything. Okay. All right. Yeah, y'all. All right. So I will see y'all in a few minutes. Bye.
I've been taking my time, I've been taking my time. Taking all of your time, taking all of your